Case on this morning's docket. That is case number 106317, State of Kansas v. Roger William Hollister.
May it please the Court, Sarah Ellen Johnson of the Capitol Appellate Defender Office on behalf of Roger Hollister. And Your Honor, I would like to request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. We are here this morning raising a couple of instructional issues that I'd like to discuss with this Court that I think both fold into sort of the same general problem with this case. The two instructional issues, one was a requested instruction for a second-degree murder instruction, and that request was denied by the Court. And I'd like to start with that issue.
As a practical matter, what will happen if we agree with you that reversible error was made on jury instructions?
As a practical matter, I suspect Your Honor is getting to the point that Mr. Hollister has died, so the convictions would be reversed.
And do the rules of civil procedure that deal with death of a party have any applicability in a criminal proceeding? Because I don't see any suggestion of death on the record here.
No, certainly the state hasn't raised anything. The standard that I've been aware of in the past in the state of Kansas is that a criminal appeal does not necessarily die with the defendant. I think if it were
necessarily, does not necessarily. But where I'm getting at is why isn't that information that the court should be provided?
It's my position that Mr. Hollister's death is irrelevant to the issues that I'm presenting. That the long practice in Kansas has been that raised trial errors that are proceeding on direct appeal do not die with the defendant, that they continue. When I say not necessarily, I'm of course hedging because I'm a lawyer and we never say always or never. There may be a sentencing issue that would become moot by a defendant's death, but a trial error, it has been the long practice in Kansas that those do not die with the defendant and that the direct appeal in fact continues.
But it doesn't vindicate your client in this case. This is not a reversal period. It would be a reversal and a remand, correct?
Correct.
And so we have engaged in an academic exercise that might be of value to future litigants, but it really doesn't have any bearing on him or his family, does it?
We're certainly not going to have a defendant to retry, no. But that doesn't change the fact that the long practice in Kansas has been that a defendant's estate, the rights of the defendant continue to have the proper review of the errors that we allege at trial.
The defendant, it's not the defendant's estate, and it's not the defendant.
Well, when
He's deceased, and the estate is not a party.
When I say the defendant's estate, I'm really meaning the defendant's legacy, the idea that the defendant is entitled to full review and to that consideration of his case, regardless of his death. Certainly, if the court wants to revisit this longstanding practice, I would ask that issue be something that we be allowed to brief. Having not been asked by this court to brief it prior to today and having not had the state raise this.
Well, the difficulty with that is that there's nothing in the record that tells us he's dead. I mean, if we didn't read the paper, we probably wouldn't know this. And do you have an obligation to bring that to the court's attention? I mean, who do you represent today?
I represent Roger Hollister.
A dead person?
Yes.
And doesn't the law of procedure generally require a substitution? Who do you consult?
I have already done the consultation with my client. It's certainly been the general law relating to direct appeal. There are cases saying that a defendant doesn't need to be competent on direct appeal because the consultation with the client isn't necessary for the purely legal issues that are raised on direct appeal. Having researched this question in the past of what happens to a direct appeal when a defendant dies, it was my understanding that I didn't have any obligation to notify the court because the legal issues still exist, and the state of Kansas has long continued to consider appeals even after a defendant has died.
In other contexts, on an appeal, we require a timely substitution of the estate for a deceased party to an appeal. And we have case law on that. Does that not apply here?
My research on direct appeals of criminal matters revealed nothing on that subject.
But most states, I think under the federal rules, it's the entire process, the conviction is void, everything's void ab initio. It's as though it never happened.
Right.
And in Kansas, the way I read the few cases, I don't see it as a long-standing deal, but I see there's a few cases. They're discretionary. I mean, the court has taken it up a few times, but it's discretionary, and there is no substitution of a party because there can't be.
Correct.
So, I mean, I guess the point is we need to know about the death in order to exercise our discretion
Well,
about whether to continue on.
in that case, I apologize for not having notified it. I truly didn't read the cases as putting that obligation on me. That was not my understanding. I will certainly.
I'm not sure it is on you. I'm just suggesting that it puts the court in a difficult position to reach this point without having anything in the record notifying us of the death of the defendant.
I note your position. I was also notified by the court over a month or two ago that the court was aware. So I know that the court had notice, or I had reason to know that the court was actually aware.
Okay. Thank you.
So now that we're at this place,
Yes.
is it your position that that it is discretionary whether we continue with the appeal, or are we required to take the appeal?
My position is that where there are valid trial error issues raised, that this court should continue to consider the appeal.
You use the word should, which gets back to ought to, but not necessarily will. I want to, are we stuck that we need to take it, or is it discretionary?
My reading of the prior cases suggests that it is not a discretionary matter when there are viable trial errors. And of course,
what case law do you base that on?
honestly, I don't have a case on this issue because I wasn't aware that we would be discussing it today. Certainly the state didn't try to argue that the appeal should be a discretionary issue and should be dismissed.
I did a case, State versus Carson, year and a half, 2 years, I lose track of time, but the issue came up that was on a search incident to arrest case, and we had 3 or 4 cases, and that particular defendant had died, and I recall the language there being that the court may continue it, and it's on the basis of whether there's some family interest or interest to the state of Kansas on the legal issue. And there we said there's a legal issue because of the facts that we wanted to plug our analysis into. So let's assume that it's discretionary for purposes of our discussion and look at those 2 points. On an instructional error versus, the admission of evidence or something like that, on where the issues are instructional errors, how do you see this falling into one of those particular silos, and then why?
Well, there is the matter of a wrongful death suit that could be predicated on a finding of guilt in a murder case, and to the extent that the murder trial was not done correctly, that could affect a wrongful death suit. That would be something that could be relevant in any murder case. I also think that the specific instructional issue relating to the second issue in the brief relating to the capital murder as a contract killing, I think that is an instructional problem, that this instruction was done incorrectly, and that it would be important to let other district courts in the future know that this instruction is incorrect, that this was not the way to instruct on that particular type of capital murder. And that issue was in front of this court in a viable case, and rather than sort of put off that issue. When it's in front of the court, it's a valid issue. I would suggest that that would be in the interest of the state of Kansas.
Well,
As long as we've reached that point, do you have anything more on the death of the client issue?
I was just going to say your third issue is insufficiency of the evidence, which does fit into what I read the rationale of retaining jurisdiction is to give an opportunity to clear someone's name.
Yes, and that was,
But the other instructional issues, as the chief indicated, would not clear Mr. Hollister's name
no.
definitively.
And thank you for putting more eloquently what I was stumbling towards with Justice Moritz as far as the defendant's estate or legacy was what I was getting at inartfully.
Having reached that point,
Yes.
can we talk about the merits a little bit of the capital
Yes.
murder instruction? I'd like to know exactly what you base your argument on, that it's required that a second participant in a murder for hire have been part of the contract as opposed to just a participant like we have in any other crime.
It's a twofold argument. It's one based on the statutory language that says either kills or is party to a contract. The other prong of the argument is dovetailing in what we've long said about premeditated murder and aiding and abetting theory, as the Overstreet line of cases talks about, that it stands to reason that if you can't be convicted of first-degree premeditated murder or capital premeditated murder without having the specific premeditated intent, we're now taking this extra step up and capital murder and saying this is an aggravated type of premeditated first-degree murder. It stands to reason that that same idea that you can't get to capital murder purely through aiding and abetting theory without the specific defendant being aware of the specific fact that makes it a capital murder.
But the jury, well, but the thing that makes it a capital murder is the circumstances of the murder, not the level of participation. I just think there's a disconnect there, because when we talk about Overstreet in that line, we're talking about intent of the person who's going to be held criminally culpable. And here, I'm not talking about intent at all. We're just talking about a circumstance in the murder. It's still a contract crime, whether he participated or he didn't.
I
Right?
would suggest that the defendant's knowledge of the element that makes it a capital murder is essential to the question of capital murder. That we're talking about aggravated murder. We're talking about a higher crime than any other level of murder. We're talking about something very specific. We're trying to specifically narrowly tailor those defendants who are subject to capital murder, and this is, all required through Eighth Amendment jurisprudence that we very much tailor down and narrow the class of defendants eligible. And I would suggest it's in line with that, in line with the theory that we need the specific defendant to have the particular intent, that it's completely consistent and required, in fact, that for a contract killing, the defendant be aware of the contract, be a party to the contract, or be the actual killer. And I think that that's the statutory language supports that interpretation. Eighth Amendment jurisprudence talking about narrowly tailoring the class of people eligible for the death penalty, and the Overstreet theory, I think all of those combine to bring us to the point where the defendant has to be aware of the contract.
How do you define party to the contract?
Somebody who is aware of the contract, is part of the contract, is either receiving payment or making the payment.
So it can't be somebody that aids and abets with knowledge unless they receive or unless they're actually receiving a benefit or a part of the quid pro quo of the contract?
I think I'm open to the idea that aiding and abetting liability can apply if we're talking about somebody who is helping somebody, knowing that that's part of a contract killing and I'm intentionally helping you with that. It certainly leaves open the possibility that that individual is thinking there could be some payment for me in this process. My problem is,
Well,
with it-
even if they're a gratuitous subcontractor, why aren't they part of the contract?
a subcontractor could be part of the contract. The point here is that whoever is convicted of capital murder has to at least be aware of the contract. And the way that this was instructed and argued at points to the jury left open the possibility that this could have been a one-person contract that the second person wasn't even aware existed.
So he doesn't qualify as a gratuitous subcontractor because of the potential that the jury could find the lack of knowledge of the contract in the first place.
Correct. That's the argument, the crux of the argument.
But knowledge would be sufficient in your view. It doesn't have to be what we consider a party to a contract under civil law.
I would certainly prefer that a person be a party
But
to a
we're really not
contract.
talking about your preference. What does the statutory language support?
To me, the statutory language requires that you either be the killer or be a party to the contract.
So you're backing off on your knowledge being enough. Just knowledge of being a gratuitous subcontractor.
What I'm saying is that this instruction left open the possibility that the defendant didn't have even knowledge of the contract. I'm not suggesting that that being aware of the contract but not being a party to it, I think that's just not the facts that were left open to the jury in this case. We're going to the farthest bridge, and I'm not arguing about the one in the middle.
Gotcha.
Thank you. And I see that I'm out of time.
Could you,
Yes.
the facts that support a intentional second-degree murder, I read your position, but clarify it for me. What are the facts that support the giving of a second-degree intentional murder instruction?
The question here, there's no question that Roger Hollister's truck was involved, that a lot of his property was found at the scene where we suspect Patricia Kimmy was at least taken. We don't have any facts about how she was killed. We have absolutely no knowledge about, so we can't read into, there's a lot of premeditation that you can factor into with how many blows were given, or were more blows given after the fatal blow, or shots. Or,
Right, the traditional means by which we determine premeditation
Right.
might not be there, but what about the theory of it being a contract killing? Doesn't that provide the sufficient, that's premeditation in and of itself, isn't it?
I don't disagree with that. The problem in this case is the central question, and this is what the district court said, was whether there was a contract to begin with. And if you remove the question of, if you take away the contract, then we're left with a very reasonable view of the evidence that Roger Hollister found himself in the middle of this situation, perhaps willfully or cluelessly or ignorantly not realizing what he was being asked to do until he was in the middle of it, and then not stopping it or, assisting in the finalization of it. I think that's a perfectly reasonable second-degree murder, intentional murder, but where the premeditation solely belonged to Eugene Kimmy, and Roger Hollister just realized after it had begun that that's what was going on.
Was what you just articulated to me articulated to the trial court on the second-degree murder theory?
Not that thoroughly, no. But that was clearly from the audio interviews with Roger Hollister. That was clearly
There was evidence, but in terms of the request or in terms of an explanation for a second-degree murder, what you just stated.
It was not stated that thoroughly, no. But the request was made.
Right. That's what I gathered, but I couldn't
Yes.
understand on what basis it was made. That's why I wanted you to clarify.
No, there was no no thorough articulation of the basis.
Thank you.
Any further questions of counsel?
Yes.
I guess I'm still a little confused about your argument on the capital murder instruction. Your beef is with the language about the defendant or another to whose conduct he is criminally responsible. Is that problematic?
It's the combination of the elements. It's that we have the defendant or someone for whose conduct he's criminally liable killed the individual, and then later on that the killing was done pursuant to a contract. It leaves out any connection between the aider and abettor and even knowledge of the contract, participation in the contract. So that's when you read all of the elements together, that's the problem, that it leaves out that connection that this particular defendant aiding and abetting even knew about the contract, let alone was a party to it.
Did the jury get a definition of what that means, or to another whose conduct he is criminally responsible?
They got the standard aiding and abetting, some
Did
language.
they know to connect the aiding and abetting to that language in the capital murder instruction?
They were specifically instructed on, the overstreet instruction on premeditation. Right. They did get that part,
Right.
But they did not get anything to indicate that a aider and abetter had to be a party to the contract or be aware of a contract or have anything to do with a contract.
I'm just trying to figure out what the jury would understand about that the defendant or another to whose conduct he is criminally responsible, what that means, because that's not in the PIC instruction, that part of it, is it? I think they took that from another case.
It was odd language, and there was...
And I'm having difficulty understanding what it means, and I just wondered if that's part of your argument, or it's more about the whole, as you say, the combination.
It's the combination. I know trial counsel was perturbed by that language. It's odd language, I think, and not helpful. And to the extent that we're worried about jury confusion about what exactly we need to find, that doesn't help.
Any more questions of counsel? Thank you.
Thank you.
May it please the court, Gerald Kuckelman on behalf of the appellee, state of Kansas. I guess I should start out with where you guys started with the appellant about the death situation. When this occurred, I looked at the cases, and it said that the death of a defendant does not make the appeal moot. It said that there could be questions of statewide importance that need to be answered, and also that the defendant's family may have interest in clearing his name. So,
I understand that, interest in exoneration. What's the state's interest in vigorously pursuing the prosecution of a dead person?
Justice, I'm not sure that there is any interest in it. He's gone, and it's really an academic pursuit because what decision we do here isn't going to change that. And the issues presented, I'm not sure, are of such a nature that people are begging to know the answer to.
We've got separate jurisprudence on moot issues where we agree to decide those, where it is statewide importance and not capable of repetition kind of thing. So do we really need to have a separate rule on deceased defendants?
I don't see a question of statewide importance here. I don't know that it is necessary. To reverse because of an instruction is, I guess, it tells the judge he made an error, but I'm not sure that the question about the second degree or the rest of it is really an open question. I think the case law is pretty settled on it. So. The first issue about the second degree murder, there's plenty of cases that say that there's evidence to support a second degree and instruction should be given. I would submit that in this case there's really not evidence of second degree murder in this case. The evidence in this case, the defendant did not know the victim. There was no connection other than her angry ex-husband that wanted her killed. Otherwise, there's no connection between Roger Hollister and Mrs. Kimmy.
Let me ask you this. If the instruction had been given and the jury had convicted of second degree, would you be saying that the evidence was sufficient to support that conviction?
I think it would have been.
And if the evidence would have been sufficient to support the conviction, then why isn't the instruction given?
Well,
that takes the courts out of the weighing of the evidence and assessing credibility, doesn't it? If there is evidence, but we just simply think it's unlikely they would have gone with that one, they would have gone with another one, why is that our function?
Well, I don't think there's any evidence of a second degree. I don't think there's any evidence that this act just happened all of a sudden. The evidence was that he traveled a considerable distance to get to her house, and that it's in a rural area. There's no reason for him to be there. I mean, it all points to premeditated. I don't know how it could have been an intentional killing without premeditation under the facts that are in this case. There's no indication that he was there and got in an argument or anything. There's no...
What evidence we have that this defendant knew when they left in his pickup that they were going to go kill the victim?
Well, we have 2 months prior to the killing, the defendant is with the ex-husband. The ex-husband's talking about wanting her killed. The ex-husband's talking about paying somebody $70,000 to kill his wife. And then when you see the subsequent actions after the killing, when Roger Hollister goes to collect the $70,000, would certainly indicate that he knew what was going on and he was going to get his pay. Would be my response to that. I think that the evidence that he knew, if you take the whole picture of all the facts, it points to that he knew what was going on and he was going to benefit from this killing. So,
But it's circumstantial.
it is circumstantial.
And the jury didn't have to draw the same inferences that you're drawing.
They didn't have to.
And that's where I'm at. If they don't have to draw those inferences, and they don't draw those inferences, why wouldn't the evidence support a second-degree murder?
I think if they didn't draw that inference, they would find him not guilty. I don't think there's any inference. I don't think there's any circumstances here that would lead them to conclude that he all of a sudden got upset and shot her or killed her in some manner.
But there was direct evidence placing both defendant and his vehicle at the scene.
There was.
And so that's not an inference that he was at the scene.
That's correct. I don't think there's any question he was at the scene. He gives statements admitting that he was at the scene. So all of the evidence.
Well, see, I'm having trouble then if you put him at the scene of a murder. Why that wouldn't support a conviction? Why the evidence wasn't sufficient to support a conviction for second degree? If you don't draw the inference from the circumstances that he premeditated or was part of the contract.
Well, if it wasn't premeditated, could it have been second degree? Maybe so, but there's no evidence of that. There's nothing in the record to show that it was in fact a second degree. There's no indication of it. It all points to premeditated.
The evidence has to refute premeditation before you give the second degree?
Well, I think there has to be some evidence that it was a second degree. That it was intentional but not premeditated, and there's just nothing anywhere to indicate that.
But that isn't the elements of second degree. When you instruct the jury on second degree, you say intentionally killed. You don't say intentionally without premeditation.
Correct.
Okay.
Is there a difference in who was doing the requesting here? For example, this instruction was requested by the defense, is that right?
Yes.
And our case law, I believe, says that we have to look at the evidence in the light most favorable to the defendant when he makes that request.
Correct.
But on the other hand, if there had been a conviction of second degree and you were up here arguing there's sufficient evidence to support that conviction, you get the benefit of the evidence, is that right? The evidence is viewed in the light most favorable to the prosecution.
Yes.
Is that a distinction? Or is that a difference here?
Well, I go back to the point, I don't think there's any evidence that it was second degree. I just don't see how it could have been a conviction for second degree. I just think based on these facts, I think the judge correctly instructed either it was an intentional and premeditated killing or else he was not guilty. I guess the jury could have concluded that he didn't know what was going on at all. you know, that he drove Mr. Kimmy there and Mr. Kimmy was the killer and he just drove him and didn't know what was going on. I think would be far-fetched, but I think they could have made that finding. But it still wouldn't have been a second degree because Mr. Kimmy wanted his wife dead.
All right, thank you.
Counsel, if we disagree with you on whether there's error on the second-degree murder instruction, have you argued that the error was harmless?
Well, I guess in light of Mr. Hollister's death, it isn't going to make any difference. If he was alive, would it be harmless? I suppose.
Actually, my question was just, have you argued that up to this point?
No, I haven't.
Okay. Could you address the other instruction issue that your opposing counsel talked to us about on capital murder, please?
The instruction that was given where it says that the defendant did the killing or someone that he was responsible for, I think is the only way you could give that instruction to make sense to the jury. If the language that was added had been left out and it just said the defendant killed, then that would preclude the fact that perhaps he was there assisting Mr. Kimmy and Mr. Kimmy was the trigger man.
Okay, that's the part she said she thought made the problem worse, but that's really not the part she's attacking on appeal. The part she's attacking on appeal is a failure, what she regards as a failure to instruct that Mr. Hollister had to be a party to the contract, or at a minimum, at least aware of the contract in order to be convicted of capital murder, and that the jury was not told that.
Well, I think maybe the language was that's the PIC instruction that's recommended, but perhaps it's vague that if he didn't know about the contract at all, I don't see them convicting him of capital murder if he's not involved in the contract at all.
The instructions as given did not hold open that possibility, as your opposing counsel suggests?
I guess that it was open, but the evidence in this case, when he goes to collect the money after the killing, I just don't see where a jury would have been confused that he wasn't involved in the contract. He goes to collect the money, which would sure be strong evidence that he knew the contract was there and that he was a party to it. The defense didn't argue that he wasn't a party to the contract. That wasn't their argument. So, and I'd also note the comments in PIC have a comment that language should be added in. I think they cite a case, Burton or Bruton or something, but anyway, I think the judge was following what was recommended in PIC.
You have any further presentation for us, counsel?
Unless the court has any other questions.
Any more questions? I see none. Thank you.
Thank you.
We reserve 3 minutes for rebuttal.
Unless the court has questions, I would waive rebuttal.
Any questions for counsel? I see none. Thank you. Thank you both for your arguments this morning. Court will take this matter under advisement.